In looking at the consolidated pretrial order, it sounds like the primary issue that divides the parties is it's referred to as the premarital home, a house. Going to need to work through that. But Mr. Cidato, I saw that you also in your response indicated that your client seeks an equitable division of all marital property and debt. That's a little broader than just the house. I'm going to actually start with you just for setting the scene. We're not getting into substance yet, but I want to make sure that during our time together today, we cover everything so that whatever final order I enter is comprehensive. I wouldn't want you all to have to come back because, hey, you didn't talk about the car. Who gets the Ford Escape? I know there's a house and it's trending towards foreclosure. We need to work through that. What else is out there on your client's radar?
Your Honor, actually, if it's Your Honor, and I know it's unique with pro se litigant on the other side, but in light of the pretrial order opposing party side, I was wondering if we have a pretrial because this might be able to be solidified, get this going pretty quickly and come to resolution potentially. Okay, when you said have a pretrial, meaning you speak with Ms. Galt? Or I think just with the court,
that we all talk.
Yes, Your Honor. I think that.
Well, we're all together, but why don't you first start by answering my question, which was, what do you see needing to be resolved through today's hearing? Just the disposition of the house, or is there more than the house? I know there are no kids, so that's good, but is there more than the house?
So, Your Honor, in light of information that the opposing party provided in the last 10 days that the house is foreclosing imminently, I think within the next week or so. At this point, our position is going to be, they've been married June 19, separate for a year and a half now, just go in their own direction. I think so at this point, and again, between that and the pretrial order, or at least a part of it, that's going to be removed from the table. I think at this point, we're just looking at separate assets here. And so to answer your original question, given how far along the process with the home, our assertion is that still a marital component to it, but in light of the information that's supposed to be imminently foreclosed and sold, that is no longer an issue today. We're bringing forth to the court.
Okay. Well, let me hear from you, Ms. Galt, as to what you think the issues are that we needed to work through today. I know the house, but then Mr. Galt's lawyer included this language about all marital property and debt. And so sometimes in these hearings, we work through the fact that there is a Visa credit card that has $10,000 owed on it. And we need to sort out, do you get $5,000 and does Mr. Galt get $5,000? Or the evidence is actually you spent most of it, so you get $8,000 of the debt. And sometimes there's other property like a car or the furniture in the house, et cetera. You focused on the house, and most of the response from Mr. Galt focused on the house, but there was this little bit about other marital property. Have you two already, you're in your space, he's in his clothes aren't in your house, his furniture is with him?
I think with the house, one of the main concerns is the allegation of dissipation, which I have evidence for that. And the other concerns with it being a premarital property and me trying to save it, and all of the evidence showing that he agreed to leave the home, he agreed to the sale of the home and end up sabotaging those things. And me not being able to live in the home because not feeling safe because of his threatening behavior has led me to not be able to be in the home. So I would like my rights to the home restored, and also the grounds of why the house is facing foreclosure as well, for that to be cleared up.
So we'll talk about the former, about whether you can get back into the house, et cetera. I have some questions about that. Why it's facing foreclosure isn't really something for me to get into. I mean, you may want to educate me, and Mr. Galt may want to educate me through his lawyer as to why he thinks it's facing foreclosure. But the legal reasons and why the lender may be seeking to foreclose, that's nothing I can modify. I wouldn't be able to tell the bank, oh, you know what? The foreclosure isn't Ms. Galt's fault, it's Mr. Galt's. That's not properly before me. But let me ask you a couple other questions. So you don't, what's the address, just the street address of is it the Peyton Woods Trail?
Yes.
Okay, so I'm just gonna call it Peyton Woods. That's what we're calling the premarital home? And that's where you lived before you married Mr. Galt, or the other way around?
I purchased it, but we moved in at the same time.
Okay. And when you say you purchased it, you went to the closing and the deed is just in your name?
Yes, and all the funds to purchase the home, make any kind of structural improvements, that's been all of me.
Okay. But when you moved in, Mr. Galt was with you.
Yes,
Were you married at that time?
no,
Okay. And now, does Mr. Galt live in that home?
yes,
He has, oh, that's his lawyer's address. So, Mr. Galt is at Peyton Woods, you are not?
correct.
Okay. And have the two of you agreed, as to who needs to move out? Or that's part of what we need to work out today?
What we need to work out.
Okay. If Mr. Galt were to move out, and take with him his clothes, things like that, are there items in the house that you think we would need to sort out as a group, so that it would be in an order saying, and I'm not saying you have to move out, so don't panic yet, but if the ruling in the end is Mr. Galt goes somewhere, Ms. Galt stays in the house insofar as she can keep the house, Mr. Galt may have things that he wants to take with him. Do you see any issues about what should stay and what should go, or it's pretty clear this is Reese property and this is Valeria property?
I think we would need to have the court intervene for clarity for that.
Okay. All right. So Mr. Cededo, I guess I'm a little confused, but maybe we're starting to have the conversation you wanted to have. It sounds like it's a little more than just the house, and maybe that was to your point of the marital property, et cetera. And I'm not quite sure, maybe you could articulate, or you want Mr. Galt to articulate what you had in mind about, I think we can just sort of, people will walk away from things. It sounds like in Ms. Galt's mind, that would mean Mr. Galt would need to leave the Peyton Woods address. I don't know that that's what he was thinking he needed to do. So why don't you give me a little background as well? And this is still an informal discussion. If we need to get formal and people tender evidence, et cetera, I'm happy to do that. But if we can make headway this way, let's do it.
Yes, Your Honor. So my understanding is that the parties separated early last year and that there was talks last summer, and my client was on board selling the home. They went back and forth about either selling the market, selling to him. I'm sure the evidence will show that there was text between the parties. My client will not dispute that. And then around December, when opposing party listed the home and filed for divorce around the same time, my client at that point did not want to have this home sold. He did seek me out. Opposing party did put it in the market. They didn't have a buyer. My client wanted to buy the home from Ms. Galt, and he hired me. I filed less pendants in the case, and then there was back and forth between the parties about, well, myself and opposing party about getting the home sold. Ms. Galt did make it very difficult because she's on the mortgage itself, and I tried to explain to her, the evidence will show that my client was trying to get money together to pay the accelerated amount, because we didn't find out until March or early April at mediation approximately that the loan was accelerated at that point. So I do have messages that for whatever reason, opposing party just couldn't understand that my client could not call the mortgage company to talk to them. And again, this is how mortgage companies are, despite being married or not. So he did pay.
Meaning the mortgage company would speak to Ms. Galt. They wouldn't speak to your client.
Yes.
They would speak to Ms. Galt because the mortgage is in her name, the property is in her name.
Yes.
And Mr. Galt couldn't say, well, hey, let me see what I can work out with you. That you're not the person with whom we will work something out.
Yes.
Okay.
And I do have an email from opposing party saying that he can go to the bank to pay, but he needs to reconcile, or she'll work with us when he can reconcile. Sorry, when we changed, because in our discovery, or our mandatory discovery, he put his assets, but opposing party could not wrap her head around the fact that my client can borrow money from people. There's $6,000-7,000 here, so she stated in an email, until you guys discloses everything, which we did. But again, two things be true at once. Both my clients don't have money at the time, he's working, and also can get money from other people. So this has been going on since March, and I have several emails asking opposing party to work with us. I believe the first one says, I don't have access, because I think the credit union shut her account down. But just because the credit union shuts your account down does not mean the loan's gone. Wouldn't that be nice? So at the end of the day, I was trying to work with the opposing party to get, when she said, I don't have access, well, it's only in your name. So that's March, April, May. We found in April that the loan was going to be accelerated into foreclosure as early as May. And then I got an email about, I think in the last 2 weeks, that it's imminent. So the reason for the change here is because at this point, it's a lost cause. I mean, there's no way to determine any equity. I think there was minimal to begin with, but this, so just to accelerate this, they have been apart for a long time. Again, they've been married for just over 7 years, June 19, February of 25 is when they've been separated. She lives, to my understanding, up in DC area, works up there. My client is a trucker by profession. And he's been out of work for, I think, the last month or 2 months and finally got back this week, I believe. But given that point, that's why we're not certainly, we go to a formal hearing here. We'll put up evidence that I think that it was kind of a combination between the parties. I think opposing parties going to make it seem that my client here. But I think at the beginning, there was a plan, my client, which was his right, to block it during the pendency of this case as it was pending in February. But then if the court, I would say to the court, it's both faults. My client more in the beginning, if the court was going to, lack of better terminology, look at fault, because my client did switch lands here, but opposing party made it impossible the last 4 or 5 months and has led to this because my client was trying to get the money together, but he could not simply go to the bank and pay them. As an email, she says to me, why doesn't he just go there and pay? This is not how mortgage companies work. So now the house is gone. Like I said, my understanding is within this week or the next, it's going to be sold off. So with that said, my understanding is my client knows that he has to be out soon anyway. So that's why instead of, waste the court's time that beyond the small things in the home that, I do think that it should be accounted for, but given the income between the parties, I think that at this point, just for lack of better terminology, it is a lost cause. And at this point, besides that, there's really other big ticket items. There's some premarital vehicles my client has. There's a truck. I know opposing party has a vehicle, but there's not a lot of savings. There's no retirement accounts. It's really just, they walked away from each other a year and a half ago. And I think that'd be the best resolution today.
Okay, sure. So Ms. Galt, you live up in DC these days?
I've relocated.
Okay, I mean, you can live wherever you want. I just was responding to what, but you don't live at the Peyton Woods address?
No.
Okay. So it sounds like Mr. Galt is prepared to walk away from the property because he and his lawyer view it as a property that will be foreclosed on, and so he'd be evicted anyway. What's your understanding of the latest from the lender?
That the home would be foreclosing August 4th. There's also been ample time to pay the mortgage, which I will get into, and the means and challenge in which I explained several times and shown Mr. Galt as well. I believe this, the whole issue has been an issue of abuse of the court's time and stalling throughout this entire process from Mr. Galt and his counsel.
Let me stop you for a sec. I will hear you out on all that, but are you planning on taking any steps to prevent the foreclosure, or you accept it as that's pretty much what's going to happen with the Peyton Woods address?
I have possible gifts, but I will not be gifted the finances unless the house is solely granted to me.
Okay.
And also researching and exploring other channels I can take before then as well.
And when you say solely granted to you, isn't the house already in your name?
Yes, but at one of the first hearings, the judge stated that at the last hearing, it would be decided what happens to the home, even though it's premarital due to Georgia law. Okay,
well, and usually that other judge puts in place an order that says, don't transfer anything. We freeze everything until these proceedings are done. And so even though, I'll just use an example, your car might be in your name because you were a couple, just don't sell your car. Hold on to it till we get through the end of it to make sure that the decision isn't, well, actually, Mr. Galt gets your car. So you think that you may be able to salvage the house, meaning keep it in your name, and that's your intention? Or you're just sharing with me, I could do it, but look, I've moved on, and really what we need to do is close the chapter on the Peyton Woods address?
It is my intention. I would like to live in my home.
Okay.
Am I able to present everything else that I had as well?
You will be able to. I just want to, I don't want, like you, I want to conserve everyone's time. And so if there's stuff we don't need to cover, then we shouldn't do that. So you'd like to get back in the house and you think that you can line up financing that would prevent the foreclosure.
Yes, and I'm not seeking anything else from Mr. Galt. I'm not seeking for him to pay off my debts or anything else, just.
Okay. Are you aware of any shared accounts?
No, we've never commingled funds, never had accounts.
Okay. You mentioned some things like dissipation and whatnot, but if my ruling in the end is that the Peyton Woods address goes with you to save it or not to save it, whatever you're able to do, then Mr. Galt leaves the relationship without Peyton Woods. That works for you, or is there some amount you also are seeking to collect from him because of some of the things you've described?
No, not seeking any kind of amount from him.
Okay, it just would be a final order from me saying, as a result of the divorce, the Peyton Woods address goes to Ms. Galt.
Yes,
Okay, and then you take it from there with the lender.
yes.
Okay. All right. Anything else in terms of marital property?
We don't have any.
Okay. You agree that insofar as their vehicles, there's a vehicle, more than one, that's clearly Mr. Galt's, and there's a vehicle or more than one that's clearly yours.
Yes, and also I signed for his Mercedes, and I'm on the title, but I'm not seeking that.
So we'd need to get the title moved over into his name.
Okay.
I mean, you wouldn't be opposed to sign it. We wouldn't do it today, but if the order was within X number of days, Ms. Galt will sign over the title and we need a descriptor with some of the VIN, the Mercedes to Mr. Galt. You don't have any issue with that?
No.
Okay. I'm just making a list.
Mhm.
What else? Because you said nothing and then you're like, wait, there's a title to a Mercedes. What other things might fall in that category of, oh, for Mr. Galt to get that, I might need to sign something or give him a key because it's in a storage unit?
Nothing else. I believe I contributed to one of the truck, but again, I'm not seeking anything from him.
Okay. So as far as you see it, I need to enter an order that makes plain that the house is yours and that you would transfer the title to the Mercedes. And there's only one Mercedes?
Yes,
Okay, the Mercedes to Mr. Galt. And you think that will cover everything?
yes.
Okay. Mr. Cidato, tell me what you think about that. Or more importantly, what your client thinks about that.
Yes, Your Honor. A little complicated. My client does want to also believes he wants to stay in the home, but again, what's difficult to really tell the court right now is because I just found out August 4th was the date that this house is going to be sold. Opposing party did say within a few weeks, so no harm, no foul there. But it is one of those unique situations where there's an asset that has a premarital component. We argue it has marital because my client did contribute to the mortgage for many months during the course of the marriage, but it's about to be sold, and without knowing the acceleration or the full amount of money before auction, or if it's even possible, because again, I'm no expert in that type of law, but at this point in time, I'm not sure when the deadline is for either party to be able to even come up with the money to buy before foreclosure. So it's a tad bit difficult to determine that just because. So I guess, forgive me, I suppose I need to speak in the abstract here because I can't get very specific, because if I ask the court, candidly, my client wants to keep the home, but coming out of that money and also not knowing that might be all done by today. I'm not sure. I mean, it's what, 2 weeks from today? Exactly. Yes. 2 weeks from today is the 4th. Correct. So I'm not sure if this is so. Ideally, my client's position is he wants to keep the house, but I think we need the court's guidance for either side to be able to even go that direction.
So what would the basis be if Ms. Galt purchased the house originally using her funds? What would the basis be for awarding the house to Mr. Galt? I heard you say he paid the mortgage sum, and I guess we can get into, if we need to, the nitty gritty of over the many years, because it sounds like it was many, who paid more. But that to me seems like is resolvable, not by saying, well, Mr. Galt paid the mortgage more often, so the house is his, as it would be if there is equity in the house, then Ms. Galt might need to give some pro rata share of that equity to Mr. Galt.
Yes.
If that equity was achieved by paying the mortgage, if it was not an interest only loan. And the other way I see Mr. Galt getting, I'll call it his investment back, would be if Ms. Galt's not successful in saving the home from foreclosure and it's sold, but there is some excess that goes to the owner, and the owner would be, it sounds like on the title, Ms. Galt. Maybe that money goes in the registry so that we have a conversation about, I'm making a number up, but if 50,000 is what the excess is after the property sold at foreclosure, maybe not all of that goes back to Ms. Galt, because if we look at the numbers over the 6+ years, 5 of the years, it was Mr. Galt paying the mortgage. And so he is entitled to some of the equity. We'd have to do the math. It's doable. It's not complicated. It's just, to your point, it's not known now. And if instead the outcome was that Ms. Galt did salvage the home from foreclosure, we could look at what equity is in the house and was any of that equity built up during the time the two were married and occupied the house and Mr. Galt was contributing to it.
Yes, Your Honor, may I ask my client for a moment?
Sure.
Yes, Your Honor. Speaking of my clients, given, again, forgive me, I like to be very prepared, just, I hate speculating in court. But with at this point, yes, Your Honor, our position would be that if the court was to go that direction and award the home to Ms. Galt, that we would ask for a percentage in either scenario, whether the house is salvaged, as Your Honor stated, and, or the alternative, just a number. But again, it is a tad complicated because, so we yes, pro rata would of some sort would be what we're requesting and getting those numbers, but yes.
Okay. And Mr. Galt, I'm asking you directly, but if your lawyer says, wait, let me answer that, that's fine. Ms. Galt shared with me that the only other thing she could think of that would need to be addressed in an order would be the title to the Mercedes, that it's titled in Ms. Galt's name, but it's effectively your Mercedes. And so for you to be liable, responsible, and truly to own it, if you're going separate ways, we ought to get that title over into your name. So we need to sort out what's happening with the house and get the title of the Mercedes in your name. Are there other items of significance that you think we need to talk about here so that I, one, get input from both sides, but two, include them in a final order that would govern how things are wrapped up?
Besides my trucks, I would like to retain ownership of my trucks as they are viable for my business. But other than that, I do not have any opposition to taking my title in my name.
Okay. The trucks are in whose name?
Mine.
Okay. Well, no one was trying to take them. So you get the trucks. I just want to make sure you're not thinking of something else of, oh, you know what? We have a second property or that we lease out and we need to figure out what we're going to do with that. Or if there is some other significant asset that we need to address, who gets it or how do we divide it? But it sounds like if you've got a bank account or a savings account, that's in your name and there's not funds commingled coming from Ms. Galt as well. Is that correct?
Correct.
Okay, so it's easier to separate things out. Certainly you keep the trucks. And now the Mercedes would go to you, would just get the title in your name and that leaves the house, which is what was the focus of things. Okay. So Ms. Galt, I'm happy to hear more from you if there's more you want to add, but I'll tell you that it is sounding like what Mr. Galt is agreeing to, not that his agreement is essential to how I'll rule. And so maybe more importantly, the way I'm leaning and ruling would be to say that the Peyton Woods property would go with you to save if you can save. If it gets foreclosed, then there may be some excess proceeds. The part I'd like your thoughts on beyond whatever you're going to add is this notion that I brought up about, let's just say a hypothetical. If it is sold at foreclosure and there are excess funds of $100,000, do those go entirely to you, or is there some math we need to do that would recognize that over the course of the time that it was a shared property, Mr. Galt put funds in, and so he ought to get some percentage of that excess?
I would say, if it pleases the court, that I'm able to share equity and for the sake of time, but there were no funds, no structural improvements and things of that nature, and I paid the mortgage maybe 80% of the time solely by myself.
Okay, and when you didn't pay it solely by yourself, was it a combo payment or half and half?
Yes, which we've gone into Delta Community together, which we made payments on the phone, and which he's seen done by the mail as well. So he was knowledgeable of those ways to make payment.
Okay, and what kind of work were you doing and maybe are still doing?
I've had intermittent joblessness. I was on a deployment, a contract doing counseling for the government overseas. And then when I came back, I didn't have a job and I wasn't able to secure one. So it's just been on and off finding contract social work.
Okay, where were you deployed overseas?
Germany.
Okay. Was this a military contract or a? Got it. All right.
I would like to also share that why I'm expounding on the court's abuse of time is because this seasoned attorney knew that there was no equity from the beginning. I have a default judgment dating July 23rd of 2025 of a debt consolidation loan for over $88,000 that put a lien on the home. Not only did it do that, it garnished one of my accounts that I have no access to. It took all of my money. It took everything, even incoming money, like my personal tax returns. So that account. And then plus I have.
What was this? Your money was being sent to pay what?
A debt consolidation loan by Pinnacle Bank. It was a marital debt, even though it was in my name.
Okay.
So I shared the proceeds with him. And when I wasn't able to pay, which was pre-divorce filing, I wasn't able to pay. And so over time, they were granted a default judgment.
So you jointly took out a loan that consolidated debt that you had?
I took it out.
Okay.
He benefited from it.
Okay.
And which is one of the things I think he was saying that he would pay. And so this put a lien on the home. So not only do I have that being garnished and a lien on the home, I have an Amex that I wasn't able to pay, which has a lawsuit and a possible lien. And this attorney has known that since July of last year, 2025. So there's no equity to split.
Why? Oh, because there are liens on the house. So that if it is sold in foreclosure, you're at the back of the line.
I owe money, yes.
Pinnacle will grab what it can, and Pinnacle and Amex can duke it out as to who gets what. But obviously the mortgage lender would go first. But if there is some excess value, then that may get swept up by Pinnacle and or Amex.
And other creditors. There are about 7 of them that I was not able to pay.
Wow.
So, yeah.
Okay. Well, if there is not equity in that house, then we don't need to worry about that math problem of, well, would a percentage of the excess proceeds go to Mr. Galt and a percentage go to you versus all of it going to you? It sounds like if the house is foreclosed on, there will be no excess for you, and you may still continue to owe some of these creditors.
Yes.
Okay.
And I would also like to add on the allegations of me withholding information that their Exhibit 9 of the loan statement is what I provided to them willingly. And on the second page, paragraph 4, it tells you how to pay the bill. And also, not only do all their exhibits support what I've been saying as it being in communication, and all the exhibits also in Exhibit 8 tells you how to pay the bill. It tells how much was owed at that time. And also, Mr. Galt has had firsthand experience in paying the mortgage. There just has not been any kind of intent since January to make it up to date. And even the correspondence with Mrs. Sedano about since February, about asking that they can bring a cashier check, which I have an email, and the other avenues that they can take to pay it. That's why I say it's been stalling methods, and there's been no intent. And there's been knowledge that there's been no equity, so there's just been a great abuse of everyone's time, including courts.
Okay, well, I appreciate you sharing that. What I'm hearing from both sides is desire to keep the house. And so you could call that intent, but maybe not the financial capacity to do so, because you both unfortunately are encountering some employment hard times and have some debts that are owed. So I'm hearing both sides say, not together, but I'd like to stay in the house. I'd like to get back to my house. That's Ms. Galt. And Mr. Galt saying, I'd like to stay in it. And those are both understandable desires, but if there's not the checkbook behind it, that's hard to do. And it sounds like work is slim, although something just picked up for Mr. Galt and Ms. Galt. It sounds like you've got some potential gifts that could salvage it. I don't know how one navigates that with just 2 weeks to go, but I'm sure the lender, they just want their money. And if you've got it, then they're not going to say no if they can figure out a way to make money off it. Did you want to add something?
Yes, I would like to add that, in Mr. Galt's tax returns and W-2s, he's reported assets of over 150,000 annually and more than 15,000 a month that he's been making for the past 2 years, which I have no knowledge as to where that money has been going, which has also led to the divorce. So he's been in great financial standing to save the home and step up and has not done so. And this is per the records that of his financial statements as well.
Okay, got it. Mr. Sedato, anything you want to add?
Yes, and just to clarify, I did receive a final order from a judgment from last June, but candidly, that was in opposing parties' exhibits. Bankers Healthcare Group, there was no further information than that. And there's a judgment here, but there's nothing tying that to the home. Number one. Number two, I did send formal discovery. I was trying, the irony is this, I filed my answer 4.5 months. So this case is going very, very number one. Number two, when I sent formal in May, went to 120, I thought this case we could get going because I thought I'd get more information from the opposing party, and then it didn't materialize. So I say it's a tad bit disingenuous because of the fact that I got one mortgage statement and that was it. So I have no knowledge of, up until I met with my client on Friday to go over the judgment here, that's when I first knew of this. And candidly, until right now is when everything put together today. My client did not have knowledge of, he was aware of some liens on the home, but not to the severity of it. And again, we did not find out about the acceleration until, I believe, at mediation, end of March, early April. Might have been the first week of April. So opposing parties known, I believe she told us at mediation or through the mediator, she had made a payment for several months. So at that point in time, my understanding is my client paid up to February. So my understanding is I don't think the mortgage was paid at the end of the last year into February. So there's a couple of payments my client was given over $1,600, yes? 800, excuse me. And that was just getting pocketed. We're not going towards the mortgage. So I don't know that I don't have the mortgage statements to see what was not paid, what was. I did with one, but there was a period of time when my client was paying half the mortgage and then up till I believe January, February. So, this bomb was dropped on us only a couple of months ago. So, and again, the reason for my client, I did reach out to the opposing party. I did try to get her to call them, but she was being stubborn about it because in her mind, her own words in the email will show that, have your guy to tie together. You're not, guys, not disclose the finances. Basically, I'm not going to do anything for this. It's like, well, my guy can't call the mortgage company. He did try to salvage it for himself. And she knew that. Now, again, I will concede to the point that they both did. There was talking, it was put for sale at one point. My guy said, you know what? I want to keep it, which did complicate the process. I'm not going to say it didn't. But unfortunately, we're so close now that if that's the case, and I will defer to opposing party here, if there's nothing in there, then yes, I mean, it is what it is at that point in time. You can't get blood from a stone. The creditors will try to do so, but if that's the case here, then we're not going to fight that.
Right. Okay. Well, we don't need to go around and around on the way each side believes the other communicated or didn't. I do want to observe, consistent with one of the things Mr. Cededo said is that it may not feel like this case has moved quickly, but for a divorce proceeding in Fulton County, it actually has moved pretty quickly. I've only been involved since July 1. That's when I inherited the docket. So in 20 days, I got you in here. But at least on the court side, Ms. Galt, people have not tried to go slowly. I know that you are anxious for closure. And that's often a situation when you've got a relationship that has unraveled. So I apologize if you feel like things haven't moved quickly, but as family law cases go around the state, this one has moved fairly expeditiously. Well, here's my proposal, and if we need to hear more, I'm happy to do that. Ms. Galt, I think if I enter an order that gets the house back to you and requires you to put the title in Mr. Galt's name, the title to the Mercedes, we will have addressed the two items that the two parties need addressed in a court order. I'm offering to put more in there if you think of other things that need to be addressed. But that seems to be the way this is shaking out. That will give you an opportunity to try to salvage the house. If you can pull that off, it sounds like it will leave you still saddled with some debts, but it sounds like you're not attributing those debts to Mr. Galt. They're debts you have to bear and work through as you move forward. Is that a fair summary?
Yes.
Okay. What do you want to add?
What I would like to add is the grounds of divorce, those allegations,
Mm-hmm.
and the furniture would be the other thing, and I guess the timeliness of time frame of when he would be out of the home.
Okay. Let's start with the grounds for divorce. Let me look up the petition here. You indicated irretrievably broken.
Yes, but the opposing party argued abandonment since February 2025, which we were still engaging, and I did not ask for a divorce until May, and we were still going on dates all the way until June 2025, trying to see if it can be reconciled. And even after that, we remained in having conversation via phone and text and intimate conversations and in person as well. So the date that they are claiming is untrue and abandonment period is untrue. I didn't feel comfortable being in the home due to his threatening behavior to me and others, especially during the divorce process and throughout the marriage. So that's why I didn't feel safe to stay in the home. The other allegation is cruel treatment, which they've yet to provide any kind of evidence for this claim. And there are also exhibits of our conversations and us talking about when we're going to meet up, where we met up in person, June 2025, Father's Day weekend for a date.
Where is it that you see that Mr. Galt is trying to have a different basis for the divorce?
I think that was probably in earlier paperwork. I can't remember what it was.
Okay, I'm looking at the answer where he sets forth the counterclaim, but that was just to say we want to have things equitably divided. And I think some of this was a little formulaic from Mr. Cededo because you don't have 401k accounts that you need to divide up, et cetera. But let me see if we can clear up the grounds for divorce piece. Is there a reason that this would be for anything other than irretrievably broken?
No, Your Honor.
Okay, so I think we're all right there. Tell me about furniture, Ms. Galt.
Most of the furniture I purchased, which I have a receipt for some of the big items as exhibited. Other furniture that my mother lent, she would like to have that back as well because it was just to borrow. Her furniture would include the bar that's in the man cave, the table and chairs in the dining room, and also 2 brown couches in the living room and a bed in the guest bedroom. The only furniture that he has purchased is the actual mattress in our bedroom and the TV in the man cave. He hasn't purchased any other furniture, but I'd be willing to let him have the washer and dryer because I know he asked about those things. And the couch in the man cave that was gifted to him from my brother, I don't need to.
How many couches are in the man cave?
1.
Oh, the brown couches are not in the man cave, your mother's, okay.
His is more so tan color.
Okay, the one that your brother has gifted him,
Yes.
okay.
And also all kinds of survival equipment like canned food, things of that nature I purchased. I would like those items as well. I know he mentioned having a riding lawnmower. I have nothing against trying to take what he's actually purchased.
So the tan couch in the man cave, washer and dryer, riding lawnmower. What about the TV that he bought?
The TV in the man cave as well.
Okay. All right. Mr. Galt, are there other items in the furniture category that you think should be added to that list? I know you two were talking. Do you need me to go over the list again?
Yes.
So there's a tan couch in what Ms. Galt referred to as the man cave. You know what room I'm talking about?
Yes.
That would go with you if you want it.
Yes.
The TV in the man cave would go with you. The riding lawnmower and the washer and dryer. Are there other things that you think you purchased or you want us to be working through right now, or does that pretty much capture it?
The refrigerator.
The refrigerator?
Yes.
Okay, anything else?
Bed. Yeah, the refrigerator and the bed.
And when you say bed, there's more than one bedroom. This is the bed in the master bedroom?
Yes.
And is it just the mattress or the frame as well?
Mattress and frame.
Okay. Ms. Galt, neither of those fell on your list. It doesn't mean you can't say fine to those. But Mr. Galt is adding, he's saying refrigerator and then not just the mattress, but the whole structure. I'm gonna call it the bed in the master bedroom.
I did say the bed in the master bedroom and that he had purchased the mattress only, but I'm willing to let him have the bed.
Whole thing, okay.
He can have it.
All right, what about the fridge?
He can have that as well.
All right, done. Okay,
Your Honor.
yes, sir.
My client would also like his business interests. I think he's got a couple businesses. Again, right now, I think they're dormant, but he would just like to keep the rights to those.
What connection would Ms. Galt have to his business interests?
I just want to put it on record.
Okay,
This is Your Honor.
got it. Okay. These aren't businesses with which you are formally involved, Ms. Galt?
No, and I've yet to get any kind of financial support and I'm still not asking for it, so that's no problem.
Okay, great. So then that would leave the timing of the departure from the home. Obviously, it would need to be before August 4th, if that's when the foreclosure sale is happening, because strangers may come knocking after that. What is a reasonable window, Mr. Galt, to give you to be out of the Peyton Woods address?
I would need at least 30 days. As I just cannot afford to move.
Okay. I can't give you time beyond a foreclosure sale, if the house is sold on August 4th, then someone may show up and say you have to get out because it's not your house / Ms. Galt's house anymore. So you're going to need to be thinking about how you would manage that. But we can plan for a contingency because Ms. Galt has made clear that she's going to try to rescue it from foreclosure, rescue the house. And if she does, then you'd still need to get out, but there'd be more flexibility as to when you could get out. Ms. Galt, what are your thoughts about a deadline for Mr. Galt to be out along with the things that you've agreed can go with him?
I'd say about a week because he's had ample time and knowing that this was coming and had previously agreed to get out. And as well as if I've had a previous buyer and he's made it difficult for people to come by and see the home. He's backed the trucks up, he's took the for sale sign out, he's yelled at realtors and people coming by. So I can't possibly say that he's there because I can't trust that he's gonna do what he's gonna say he's gonna do to kind of be compliant.
Is the house on the market now?
It was under contract before the list pending, but those buyers are still interested.
Okay. Is the list pendant still in place?
Yes, Your Honor.
Yes.
Your Honor, is it possible to take a 5-minute break? My client has to express.
Sure.
I appreciate it. Thank you.
We are working through when Mr. Galt needs to be out of the house. And we can talk about that. There also is the reality that if there's a foreclosure sale 2 Tuesdays from now, none of us has a whole lot of control over that. But Ms. Galt, I had been asking you about whether the house was on the market, and you were explaining that in the past it had been, and you think there may still be some people who are interested in purchasing it. Generally, getting a house lined up for sale with inspections and this and that, that's weeks and weeks, and we've got a foreclosure sale coming in 2 weeks. Would it be your plan to try to line up a sale before the foreclosure, or what?
That is one option because we've been extending the contract just to see what will happen in court. They've already gotten those things done. And there are also other avenues that I'm exploring about getting finance also to save the home that wouldn't take 2 weeks.
Okay. Well, and that's really for you to sort out. I think what we've agreed on is that the house is going to you to save or not save. It is, it's burdened with a lot of debt, both the mortgage plus additional liens that are on there from other debts that you have. Mr. Cededo, was there more you wanted to share about Mr. Galt's ability to be out of the house?
Yes, Your Honor. We'd obviously ask for if the court could tailor this, and I know the court's not in the business of ifs and buts, but if we could say till up to the 3rd or morning of the 4th, because there are things he needs to get out of there. He's working and he's on the road a lot. Now he's backing up. So it is, and candidly, we just found out about this, that we knew it was coming, but I didn't find out it was August 4th, like an hour, half hour ago here today. So we have not had time to prepare for that. So we'd ask for the maximum amount of time, call it option 1 or scenario 1, if you will, of if the home is foreclosed on. But evidently, I was just made aware that that contract is extended. So there's information that cuts both ways. There's information that's not shared by everybody. So knowing that information, if we could tailor it to, if it goes foreclosure, the maximum amount of time for my client to get out, and the alternative, we ask for 30 days from the order, the date of the order for my client to get out so he can make appropriate arrangements. It's not a situation of just bringing his toothbrush and his pillow. He needs to get people here or hire movers and get a storage unit for money he does not currently have. So we'd ask for 30 days from the date of the order, or if, of course, the house is foreclosed on, then up to that moment, if that's possible.
Okay. Ms. Galt, I'm not asking you to disclose specifically where you are, but it will help me sort through this if I understand your living arrangements. You have a safe place to stay now. It's just not up in DC.
Correct.
Okay. And ideally, you would eventually transition back into the Peyton Woods address. If that doesn't come to pass because of financial things or whatnot, wherever you're staying is a place where you can continue to stay, at least for the foreseeable future. Is that a fair statement?
Yes.
Okay. If it's not, I'm not trying to put words in your mouth. I just need to understand your housing situation as well. And I'm not asking, tell me where it is, but it's more what it is. Like, you know what, Judge? I'm good for a few weeks. I'm not going to be living out of my car, but I would like to get back into my house.
It's just not the most stable living, but I know it can't be shared at the same time. I would ask that there be a, whatever you decide on as far as the time frame for him to vacate the home, that at least there's a time or some kind of structure about getting the furniture, my belongings out the home, so there's no discord or anything like that.
Oh, that's right. Because if there's a foreclosure, you need to get your things out as well.
Yeah, it's still there.
Yep. Okay. What's your sense as to when you think you'll know what's happening with the property? Because that sort of drives it too. If you're pretty darn confident that it's not going to go into foreclosure, then you don't need to worry about getting your things out. We need to focus on giving Mr. Galt an opportunity to line up the removal of his things. But if you don't know, I need to plan for the worst, which would be on the 4th, it could be sold. And so within the next 2 weeks, you need a chance to get things out. Sounds like a lot of stuff. And Mr. Galt needs a chance to get things out. His is a little simpler because he's living there right now.
Yes, I want to plan for the worst because even though I'm planning to do everything I can, I'm not sure. And I don't have the exact information because the home was supposed to foreclose last month, but they changed it. So I've been getting a run around with them.
Okay.
May I make some additions as well?
Additions to what?
It would be about the lawyer fees and other furniture.
Okay, let's get to that in a minute.
Okay.
I thought we had covered furniture.
It was some items that I left out that I just don't want when it comes down to it, there's no confusion. And there was another item I'm willing to give him, which is the big blue couch in the, I don't know what room you would call it, is it the family room?
Is it the only blue couch in the house? So there won't be confusion about that.
Yes.
Well, let's find out. Mr. Galt, are you interested in the big blue couch?
That's fine.
As in, yes, you'll take it? Okay.
But I would also like to keep the mustard couch that I purchased and all the.
So all you need to do is specify what Mr. Galt can take out of the house. And we've got fridge, tan couch, washer and dryer, riding lawnmower, which probably isn't in the house, TV in the man cave, the entire bed, so frame and mattress and box spring if there is one from the master bedroom, and you've just added the big blue couch. Anything else you want to add to that list?
No.
And I've already asked Mr. Galt what he wanted to add, and he said fridge and master bed, and you've said it's fine. He can, not going to dispute that. So we've covered that. You were raising something about attorney's fees.
Yes, they requested them to be paid, but initially Mr. Galt agreed to an uncontested divorce, which I paid for and which he stalled on signing the agreements, which I had to file contested and paid for that as well. And along with the financial distress I'm in, I'm not able to pay and I don't believe I should be held responsible for his decision to get a lawyer when he said we didn't need them.
Okay, got it. Mr. Cededo, what do you want to add, if anything? I'm going to go over this one more time. I have a list of things and then I got to start writing. Anything you want to add, or should I go over the list because that may trigger like, wait, I want to add this or that.
I think that'd be good.
Okay, so please, both sides, listen up. So the final order would be granting the divorce on the grounds of the relationship being irretrievably broken. The house at Peyton Woods would go with Ms. Galt to save if she can. The Mercedes title needs to get into Mr. Galt's name. I will think more about the timing of people and furniture getting out of the house, but it will address that. There'll be some specifics as to which furniture goes with Mr. Galt. Anything not included on that list goes with Ms. Galt or stays in the house if the house doesn't go into foreclosure. I'll probably put some language in there about Mr. Galt needing to make the house available for showing if you're able to line something like that up, Ms. Galt. And I may need to be on call to manage that, but that's not something that would be at 10 p.m. It would need to be sort of in normal daylight hours. But if there is some potential buyer who wants to see the house, they need to get access to the house. And then, Mr. Cededo, you would need to file paperwork that would remove the list pendants. I think that would address everything that I've heard about. Anything you want to add, Mr. Cededo, on behalf of Mr. Galt?
Yes, Your Honor. I mean, I'm sure that at this point, we're not going to ask for attorney's fees. I don't think, candidly, Your Honor would grant that this is a very expedient trial or process as well. And Your Honor knows that, us lawyers like to throw that in just in case, but I think given everything here today and the amicability, I think that, I'm going to withdraw that request. But yes, Your Honor, and we just say simply, no alimony. It's a short marriage. Again.
Well, and it wasn't asked for by our side, so I wasn't
Yes, Your Honor.
including that.
I spent bird a few times, not in the great county of Fulton County, but a few times in rural Georgia where.
All of a sudden, there's alimony slapped in there.
Yes, Your Honor. So
Got
forgive
it.
me for being over.
No. I appreciate you. I didn't mention it, but that doesn't mean I wasn't thinking about it and forgot to say something. But the petition as filed said alimony is not being sought. Counterclaim didn't bring that up, and I don't think it's appropriate here. Okay, thanks for being thorough. Ms. Galt, anything you want to add to that list?
No.
So what I propose is I will draft something up, and then Ms. Niles, my staff attorney, will, hold on one second, will circulate it with both sides so you can look at it, not to say, I don't like that, because this is going to be the order, but it would be to flag something I omitted or to correct something. I'm going to need a little more information. For example, on the Mercedes, I'm going to need the last few of the VIN or the first few of the VIN so that we're specifying which Mercedes. So Ms. Niles may be reaching out, and every email she sends will go to both sides. And if you are responding to her, please make sure you copy the other side. But I'll want to make sure we can avoid unnecessary errors in the final order. And so that's why I'll be circulating it, is more for you to confirm, no, it wasn't the big purple couch, it was the big blue couch, things like that. Okay?
May I say one more thing? When Your Honor is taking, Your Honor is determining when my client can move out, my client would request that as part of your calculus that perhaps if we get notification that the house is going to be foreclosed, but it gets kicked back again, perhaps putting a little language in there. And I'm mindful that I don't want to ask too much, but if it could tie it to the foreclosure date itself as opposed to August 4th.
Okay.
Does that make sense, Your Honor?
It does make sense. All right. Ms. Galt, anything else?
Does the final order by default include name change and things of that nature, everything being restored?
I'll let you know. This will be my first final order. So I'm wanting to make sure we cover everything. And that's one reason why I'm also circulating with you all. So that's a great question. And if it's appropriate for that to be in there, I know you put that in your petition. I saw you listed your maiden name. And so if it's appropriate for it to be addressed there, I'll certainly make that happen. Anything else?
No.
No? Okay.
And Your Honor, just to clarify, I think you brought up earlier that my client's fine with, in the event of the foreclosure, that opposing parties get her stuff as well, can make time in the afternoon for her to come by in that event. That's not going to be an issue.
For Ms. Galt to
Get her stuff in the event of a foreclosure, I know that she'll need to, my client needs to be out of the home for her to coordinate in the event of foreclosure to get her stuff out.
Right.
Yeah.
Right. It's not just one afternoon probably, but it would need to be arranged a series of windows when Ms. Galt could be there, presumably with movers, to get things out, again, in the event of the foreclosure. Okay,
I would like to add that I would want some more flexibility with that. I haven't been able to be in my home in over a year. And to say that I can just come in at the last minute and retrieve my items, I may want to spend time in the home. I need to clean the home to prep it for someone to come. The house is in disarray. The house is filthy and it has several.
well, if you haven't been in it in a few months, I guess you don't know exactly what it looks like, but I hear you
I
and.
didn't stay there, I've been in it.
Okay, I hear you. If it's being foreclosed on, you don't need to clean it up. If you are putting it on the market, you certainly want to spend some time there so that it is, makes as good an impression as possible. So I understand that. All right. I think we've covered everything. If I end up with questions, again, they'll go out to both sides. It may be a question for Ms. Galt, but we'll copy Mr. Cededo as well, or vice versa. But we will put something together and circulate it. We've got that time constraint of the foreclosure. Ms. Galt, what is the latest you've heard from the lender or the firm that is running the foreclosure, that it is going to be on Tuesday, August 4?
Yes.
And they let you know that because they sent something in the mail, or?
I've had to call because all the mail goes to the home still, so.
Okay, but you've spoken with someone who said, yes, the plan is to do the foreclosure on the 4th.
Yes.
Okay. All right. Any questions?
No.
All right. Mr. Cededo, anything else on behalf of Mr. Galt?
What's that? Sorry, one second, Your Honor. Good afternoon, Valeria. Come on. In the event of foreclosure, not just chill there. Just get her stuff out of there.
Oh, okay. Yes.
I'm still on 2 weeks right now.
Who do you have here with you today?
My parents.
Okay. So that, it's your mom's furniture you were asking about.
Correct.
Got it.
No, Your Honor, I was just explaining to my client about the flexibility, about, in the event of the foreclosure of opposing party getting her stuff. But yes, no, I think it's everything.
Okay. Excellent. We'll reach out if you all have questions and we'll get to work on this. I appreciate everyone's time. Thank you.
Same. You can get the same guy.